I'm Sylvia Idowu. Thanks for joining me on Handy Law. We will continue with the series on our fundamental human rights, provided by the 1999 Constitution of the Federal Republic of Nigeria. Today we will look at Section 35. It talks about the right to personal liberty. It says no one shall be denied their right to personal liberty except in accordance with procedure permitted by law. So under what circumstances can someone be denied personal liberty? A person may be denied personal liberty in order to carry out the order of a court for a term of imprisonment when someone has been found guilty of a criminal offense. Secondly, someone may be arrested or detained on suspicion of having committed a crime or for failing to carry out the order of a court. Other times when denial of personal liberty may be permitted for the welfare and education of a child who is less than the legal age of 18 years. Such a minor may be directed to be kept at home with the parents, guardians, or in some cases, institutions like orphanages. People with contagious or infectious disease also fall into this category. If you remember the Ebola incident in 2014, when a Liberian citizen was detained in the hospital to stop him from living and infecting other members of the society. Also, mentally ill or drug addicts may be detained for their care and treatment. So if arrested, what next? Did you know that the Constitution provides that if arrested and detained, you have the right to remain silent or avoid answering questions till after consultation with your lawyer? This provision has been given prominence in recent time by the Administration of Criminal Justice Law of Lagos State 2011 and the Administration of Criminal Justice Act 2015. These have expanded it to reflect recent trends in the society. For example, it is now mandatory for there to be a video recording of any questioning of a suspect by any security agency of the government. In the absence of a video recording, the statement of the suspect must be taken in the presence of his lawyer. Some states have also made any statement obtained contrary to these provisions inadmissible in court. Also, you are entitled to know the reason for your arrest, and this must be given to you in writing and in a language you understand within 24 hours of arrest. You must also be brought before a court within a reasonable time, which is usually 24 to 48 hours, depending on the location of the nearest court from where you are. Furthermore, if a person is not tried within 2 months of detention, or 3 months for someone who is already on bail, the person should be released without conditions, or with conditions that will ensure the person returns to court for trial. People who committed capital offenses may be kept for the duration of their trial. Capital offenses are offenses like armed robbery, kidnapping, as some states have made it, murder, treason, and in some states, blasphemy. Finally, as we say in our local parlance, if you are arrested or detained unlawfully, you are entitled to compensation and public apology from the appropriate authority. Good to know, right? Well, you may have to get to court before you can get any of this, but nothing ventured, nothing gained. This is where we'll end today's segment. If you have found this helpful, please leave a comment and don't forget to like and subscribe.